Hello, I am George Rodriguez, a business manager specializing in the agri-market across Latin America. Today I want to talk to you about a ruling that in my reading is one of the most significant of recent years for anyone who formulates, registers, recommends or applies crop protection products in Brazil. Portal AgroLink published an article by Leonardo Gottems reporting that the use of the hormonal herbicide 2,4-D now faces new restrictions in Rio Grande do Sul, following a court decision that prohibited its application in the Campanha region and established a 50-meter exclusion strip around orchards and vineyards throughout the state. Let us go to the facts precisely, because every detail of this decision has practical consequence. The ruling was unanimous in the 4th Civil Chamber of the Rio Grande do Sul Court of Justice and confirmed the understanding already adopted at first instance. The prohibited area will follow the map of the Campanha Indication of Origin. The state government will have 120 days to present a control plan, and in the event of non-compliance, a daily fine of 10,000 reais has been set. The measure is expected to affect the 2026/2027 season and will remain valid until the government presents a monitoring system and delimits protection areas considered safe. 2,4-D is used in weed management in soya, rice, wheat, and maize. According to the material in the proceedings, these 4 crops represent more than half of Rio Grande do Sul's agricultural output. The controversy relates to product drift, which can reach neighboring areas and affect mainly vines and apple trees. Reports attached to the case associate exposure with deformation, floral abortion, and plant death. The case has been running since 2020 and was brought by wine and apple growers associations. The court considered state enforcement insufficient and upheld the restriction despite arguments regarding possible economic losses and federal competence. The State Attorney General's office reported that it has filed an appeal. There are 2 technical elements in the case worth highlighting. A state report from 2022 attributed the fall in drift occurrences to applicator training and advocated good practice rather than prohibition. Meanwhile, assessments gathered in the proceedings indicated that winds in the southern half of the state hinder safe application during the soya planting period. In other words, we have evidence that training works and evidence that the regional meteorological condition is adverse. These 2 readings do not cancel each other out, they complement each other. Now let me translate the importance of this for anyone managing portfolio, registration and formulation. This decision is far larger than a regional dispute between grains and fruit growing. It sets a relevant precedent. The judiciary has assumed competence to geographically restrict the use of a molecule registered at federal level on the basis of drift evidence and an assessment of insufficient state enforcement. Anyone working with registration, formulation, and product positioning must understand that regulatory risk is no longer exclusively the regulator's domain. It has become judicial and territorial as well. And the agronomic impact is considerable. 2,4-D is one of the most widely used molecules in the management of resistant broadleaf weeds in Brazil, particularly in controlling horseweed and pigweed in pre-sowing burn down for soya. Restricting its application across an entire producing region and creating a 50-meter exclusion strip throughout the state changes the design of the resistance management program, increases pressure on glyphosate and on other modes of action, and shifts demand towards alternatives that do not yet carry the same cost per hectare. Here I speak as a formulator, and I want to be quite direct. The central problem is not the molecule, it is the physics of application. 2,4-D exists commercially in chemical forms with markedly different volatility behavior, and the formulation determines how much of the product remains on target. When a court sets a safety distance in meters, it is in practice pricing the technological deficiency of the formulations and application protocols in use. Let us turn to the favorable points of the decision. The first is the protection of high value-added chains. Viticulture and pomiculture operate with products of geographical identity, a perennial cycle and long-term investment. A vine damaged by drift does not recover in the following season, and the damage may compromise years of establishment. Given reports reports associating exposure with deformation, floral abortion, and plant death, the legal interest of these associations is legitimate and technically supported. The second is the incentive to technological modernization. Use restriction is the most effective trigger for accelerating the adoption of low volatility formulations, drift-reducing adjuvants, coarse droplet nozzles with controlled patterns, and decision systems based on meteorological conditions. The Brazilian market has historically underused anti-drift technology because it is optional. It ceases to be optional when there is a daily fine of 10,000 reais. The third is the clarity of the deadline. The 120 days for presenting a control plan create an objective window for government, industry, and growers to build a monitoring system, delimit sensitive areas, and establish application traceability. That is risk management, not merely prohibition. The fourth is the value placed on applicator professionalization. The 2022 state report itself attributed the fall in drift occurrences to training. There is a proven technical path, and it runs through training, technical accountability, and application records. The fifth is strategic anticipation. Companies that prepare now to operate under territorial restriction will be ready for a scenario that is likely to repeat itself in other regions and with other molecules. Now, the points of concern equally serious. The first is legal uncertainty in the input chain. Crop protection registration is a federal competence with assessment of agronomic efficacy, toxicology, and environmental impact. When state court decisions create their own maps of permitted use, the industry loses predictability for planning production, stock, labeling, and technical recommendation. Industrial planning does not adjust at the speed of a court ruling. The second is the agronomic risk of concentrating modes of action. Removing or severely limiting 2,4-D in a region increases dependence on fewer alternatives for broadleaf control. This accelerates the selection of resistant biotypes, precisely the opposite of what any serious resistance management program recommends. Fewer available molecules means greater selection pressure on those that remain. The third is the direct economic impact on crops representing more than half of Rio Grande do Sul's agricultural output. Soya, rice, wheat, and maize do not today have a cost-equivalent substitute for every management situation in which 2,4-D is employed. The additional cost falls on the grower at a moment when margin is already compressed. The fourth is the proportionality of the measure. A fixed 50-meter strip applied uniformly across the state ignores the real variability that determines drift. Wind speed and direction, thermal inversion, relative humidity, temperature, boom height, droplet size, and formulation type. A fixed distance is a simple administrative solution to a complex physical phenomenon. It protects in some situations and is insufficient in others. The fifth is the disincentive to the technological solution. When the regulatory answer is territorial prohibition rather than a technology requirement, investment in low volatility formulations and in assisted application systems loses part of its expected return. Punishing use without rewarding the technology that reduces the risk resolves the conflict in the short term and impoverishes the solution in the long term. And here I leave the most practical contribution of this content, thinking of those who formulate. If drift has become a legal risk with a value defined in reais per day, then drift must be treated as a formulation attribute with specification, test method, and technical claim. That means working seriously on the droplet spectrum generated by the spray solution, minimizing the fine fraction responsible for long-distance transport. It means assessing the volatility of the chemical form employed, because vapor drift is a phenomenon distinct from physical drift and demands a distinct solution. It means incorporating droplet management, adjuvants, and rheological modifiers with laboratory and wind tunnel data, not merely with empirical recommendation. It means controlling surface properties and dynamic tension to favor deposition and retention on target. And above all, it means delivering to the formulator customer and to the end user a complete technical package with a recommended meteorological window, indicated nozzle, boom height, spray volume, and a traceable record of the application. I shall close with my strategic reading. There is a legitimate conflict between two productive chains, and it is not resolved with rhetoric. It is resolved with application physics, formulation chemistry, and field governance. The case has been running since 2020, which reveals 6 years of failure to build a coexistence protocol between grains and fruit growing. The court decision is the consequence of that gap, not its cause. For the industry, the message is clear. The Brazilian hormonal herbicide market is entering a phase in which the license to operate depends on the anti-drift performance of the product, and not solely on its efficacy against the weed. Low volatility formulation, droplet management adjuvants, deposition systems, and digital application traceability cease to be a differentiator and become a condition of market access. Whoever understands this first does not lose market to the restriction they gain. I am George Rodriguez, and this has been another piece of content from Agro Latam Intel, technical and commercial intelligence for Latin American agribusiness. Until next time.